The next case is Williams v. Board of Appeals of Norwell. And this case is included because of its relevance to land of low value foreclosures. The appeals court interpreted Chapter 40A, Section 6, a grandfathering provision that allows for development of parcels which have a minimum of 5,000 square feet in size and 50 feet of frontage. The subject parcel was non-buildable under Norwell's current zoning bylaws. Next. Now, according to the Williams Court, there are three requirements for grandfathering under Section 6. The subject must not have been held in common ownership of any adjoining land. It must have conformed to the then existing requirements when it was created. And it meets minimum size and frontage requirements. The owner argued that an existing private way provided the necessary frontage. The appeals court in a previous appeal of this matter had remanded for determination whether the subject locus met the applicable frontage requirements of the 1942 Norwell zoning bylaws. Now, the land court below relied on a 1948 precedent of that court and treated the 1942 Norwell bylaws as invalid. Land court looked to zoning bylaws from the 1950s for the definition of frontage. The appeals court reversed the land court because it did not comply with appellate court instructions on remand. Appeals court held that the definition of frontage in the 1940 bylaws was good law and in effect upon the creation of the subject locus. Next. Now, they explained that the purpose of Chapter 48, Section 6 is to protect landowners' expectations of being able to build on once valid lots. The land court's reliance on bylaws adopted after the creation of the subject locus could lead to the result that a parcel originally buildable would be rendered unbuildable by after arising bylaws. Next. The appeals court did not reach the question of how to define frontage in the absence of an applicable provision in the zoning bylaws in effect upon the creation of the subject property. The court stressed that post hoc requirements could not govern the question of whether the subject locus was buildable when created and thus grandfathered. Next. The effect of Chapter 40A, Section 6 is to make buildable lots that were buildable when created, but inconsistent with later zoning requirements. Now, this is relevant to land of low value foreclosure statements. If a parcel is at least 5,000 square feet with 50 feet of frontage on a public way, current zoning rules are inapplicable to grandfathered lots. In such circumstances, current zoning bylaws should not be relied upon to prove value.